This is case number 2009-0806 in the matter of James J. Miller and Janet S. Todd.
And once again, the Chief Justice is not participating in this appeal. Counsel?
May it please the Court, I'm Joshua Gordon. I represent Jim Miller. I've reserved 1 minute of time for rebuttal this morning. If the Court doesn't mind, I'll get to the Rule 3 issue shortly, but I want to first address how the family court unreasonably exercised its discretion on the custody issue. Your Honors, if this Court affirms, its opinion will be essentially a how-to manual for the next parent willing to invent scandalous accusations to win a custody battle. Here, there were at least 7 clearly documented false accusations that Mr. Miller sexually abused his daughters. All of them were unfounded. The result, nonetheless, was a no-contact order. Mr. Miller was barred from any contact with his daughters for 2.5 years. He was allowed no visits, no cards, no gifts, no letters. The children lived with Ms. Todd during most of the pendency of this case. Beyond the personal hurt of the no-contact order, there are long-term legal consequences. First, the children were prevented from having any meaningful relationship with their father. Second, once the court ordered no contact, it is really not reasonable to think that any of the case professionals would recommend that the alleged abuser get the kids.
Well, the question really, Mr. Gordon, is what can be done about that in this case?
Done about?
You're painting a scenario that I think is very, very sympathetic, that something like this, assuming everything you say is true, should not be tolerated. But in the context of this case, where there was discretion to be exercised, and whether your client had completely clean hands or not was within the discretion of the master trial court to determine. The question is what to be done about your scenario.
Well, sure. Mr. Miller was consistently on the defensive, repeatedly castigated by everybody. But how do you expect him to act? How would any of us feel and act if we were faced with these allegations?
But we're not weighing that. I mean, I grant you that could be a rational response. But
right. But the allegations serve their purpose, and by placing the children with Ms. Todd, who was the instigator of all this, the court below unreasonably exercised its discretion in, I count, 5 ways. First, it ignored the friendly parent or the anti-alienation portions of the statute. There are 3 of them. They're fully a quarter of the statute. Factors E, F, and G all turn on one parent's encouragement of the children's relationship with the other parent.
Are you saying the trial court ignored E, F, and G?
The court didn't even mention the gist of E, F, and G in its decree.
I suppose H could be included as well.
Probably. Second, although the court listed lots of facts in its decree, the primary decisional factor was that the children already lived with Ms. Todd and were comfortable there. And so her allegations, preordained that fact. Once she got the kids in her house, well, of course, they're comfortable in her house. And this is not a case like Crawl v. Cook where this is shuffling back and forth.
Let's say that everything you propose is sustainable in the record, but that, as here, the trial court said, all of that notwithstanding, the kids, in my view, best interest is served by having them remain with mom. If we were to flip that decision, aren't we similarly using the children as pawns in other people's games? In other words, if they're actually better off living with mom, objectively, but we say, no, mom, you didn't play fair, therefore kids are going to dad, doesn't that hurt the kids, potentially?
Well, one of the consequences of the no contact order was that Mr. Miller was deprived of facts during his trial. At the time of trial, normalcy was just beginning to occur with his children. So there weren't any facts that the case professionals could look at to determine, how good a parent he was, or how well the kids were adjusted in his community, or how well they get along in his home. They had no opportunity to conduct even the most rudimentary home study. And because he had no residential history with the children, he was forced to come to court with essentially no facts to support his position. So how can he possibly win? So it's not really an objective determination because of these allegations. The third way the court unreasonably exercised its discretion is that I think it confused Mr. Miller's overall defensiveness toward the false allegations with his otherwise good parenting. And fourth, the fourth unreasonable exercise of discretion was whether Ms. Todd made her false allegations intentionally or negligent or because of what my brother calls her unique reasoning process. The court below effectively rewarded her behavior. But nationwide precedent demonstrates that appellate courts are not so easily fooled.
Is there a majority of opinion out there that says the parent who does this, assuming all the facts as pled are true, should not be rewarded regardless of the consequences to the children?
Well, I think so. I found no scholarly articles, counting up cases, but I found a whole lot of cases, as I presented in my brief, saying exactly that. And I noticed my brother did not cite any cases to the opposite. So I think so, but I'm not positive.
Was there a testimony about the effect on the children of the mother's alleged behavior?
Yes, very little. There was no expert testimony. I think Mr. Miller testified that he thought the children were harmed by learning about these allegations, whatever it is, the mode of them having learned about it. And I think that constitutes the fifth unreasonable exercise of discretion.
But I mean, it seems to me that the ultimate question is the best interest of the children.
Yeah.
And if her behavior is harming the children, that would be a reason to switch custody. So if the record doesn't have a lot of evidence that the children were harmed, then it's hard for us to reverse the trial court's determination.
Well, there is psychological harm, and if you look at RSA 169C3, which I've provided to the court this morning, and it's inaccurately cited in my brother's brief, but it's accurate in what I've given you this morning. Even though the kids were not molested, they believe they were, or fear they were, or something like that, and I think that comports with RSA 169C3 Roman 2C. The child exhibits symptoms of emotional problems generally recognized to result from constant mistreatment. So the facts on the record do support some psychological harm.
Given your position that the mother's conduct precluded the father from building a track record with the children, I'm wondering if there's some middle ground where in situations like this, the way to deal with it is to allow the father to have a track record, not to simply punish or reverse custody permanently. I'm just asking the question, would there not be, given your argument that it was her conduct that allowed him not to have the opportunity to demonstrate his good parenting skills, as you say, whether in this kind of situation we ought to allow him the opportunity to demonstrate his abilities and somehow put the final decision-making off?
I think it's a possibility. I think as a practical matter, it may be more difficult. And if I can take a fact from this record, on the eve of trial, or not long before, one party, I think it was the mother, asked the court to continue the trial some. And the court said no, on the basis that these parties have been very acrimonious. The litigation's been going on forever. And there needs to be some resolution of the case. So as a practical matter, I'm not sure trial judges are going to be happy with that.
So given that, your position is, as a practical matter, we really can't do something like that. In the absence of a record, track record, with your client's interaction with the children, as an appellate court, we can't really speculate, well, if he had been given an opportunity to really develop his relationship with the girls, everything would have been hunky-dory. I don't think we can speculate on those issues.
No, there are some facts in the record, of course, that my client is a good dad, and the kids have been out there, but they're nowhere near the depth of the record that the mother brought to it. But if the court affirms, as I said, it provides a roadmap for how to game the system, and the next litigant will, just, this will be how you do it. You accuse, get some corroboration, get the kids to your house, get a no contact order, and the accusations have to be just barely believable, something less than probable cause. All you have to do is get some case professional to go off to DCYS.
One of the issues that you raised is respect to the tapes, and they say in their brief that you got access to the tapes. Mr. Miller had access to the tapes 3 months before the trial.
Yes. He got access to the tapes 3 months before trial, but he didn't get access to the tape 2 years before when they were made. And of course, these tapes contain exculpatory information. Had he had them, he, I think, would have used them or tried to use them to prevent the 2.5 years of separation.
Well, isn't 3 months before? I mean, the issue is whether or not he's prejudiced at trial by the failure to disclose.
No, it wasn't. The tapes are not really relevant to trial. The tapes are relevant to this 2.5 year period of separation. The tapes contain, I urge you to watch them, they're very short. They contain this little girl saying, something to the effect of, I don't want to mischaracterize, but, mommy told me what to say.
Yeah, but what I'm not sure what the 2.5 years of separation has to do with the outcome of the trial. Can you explain that?
No, technically this tapes issue is moot. It's like ATV versus Dredd. Technically, this is moot. But thinking through for the next case, had Mr. Miller had these tapes a long time ago, he would have used them to advocate for not having this long period of separation, which prejudiced him at trial by not the long period of separation, then prejudiced him by not really having a record of facts.
Let me ask you about the Rule 3 issue.
Yeah.
Reading your brief, it sounds like there's no specific statute that prohibits alleged discrimination on the basis of marital status. And the issue before us, assuming it's based on marital status, is a constitutional issue. Is that right? Am I reading your brief correctly?
Yes and no. It's not. There is no statute on point. It's a constitutional issue, but it's not really marital statute. This case isn't really about whether the parents are married. It's about whether the children.
The case isn't about that, but our rule is. Our rule is based on marital status, not on the legitimacy of the children.
Yes,
that's what we have to decide is the constitutionality of the rule, not as it applies to this case.
Well, but that's the effect it has. Maybe it's an as-applied and not on its face challenge. I'll accept either of those. But whether the parents are married or unmarried is that the children are identically situated. And the purpose of the rule is to, is repeat appealers. And there's another way to do that. We can have a notice of appeal check mark that says, has any party appealed in this case before? And you get a mandatory one time and then discretionary thereafter.
If the purpose of the rule is simply to regulate our caseload, is that a rational basis for the rule?
I think it's a rational basis for the rule, but you don't get rational basis review here.
Well, I'm not sure how it regulates our caseload. It's going to come here as an appeal. It's just a question is whether discretionary or mandatory.
I think I'd have to read the First Circuit case on this court's appellate discretion. But it's a constitutional issue, and it's not the parents, it's the children. Thank you very much.
Thank you. Than others. Did you have anything to add, Mr. Gordon?
Judge Duggan asked me whether this was simply a constitutional case or statutory as well. I want to point to RSA 354A1, which I've quoted on page 31 of my brief. The general court hereby finds and declares that practices of discrimination against any of the inhabitants based on blah, 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 blah. That includes marital status and familial status. So I think perhaps it also is.
That's a general purpose provision.
It is.
It's not a specific statute, but you're right. That does cover it.
The second thing I want to say is, although there were some backs and forths with these allegations, ultimately all of them were unfounded. Third thing I want to say, and the final thing, is with Peggy Ward, whose report everybody respects, is she concluded that the reason that Ms. Todd, quote, unintentionally but clearly caused Laurel to come to believe that she has been sexually abused by her father is the hypothesis best supported by the data. How she did it, intentionally or negligently, or by her unique reasoning process, she made the kids think so. Thank you very much.
Thank you. Case submitted, and the court will take a recess.